Good afternoon, everyone. Let's get started with our meeting today. We have one bill hearing and then a bill or two that we hope to still work. Would like to welcome Representative Miller to the committee. He's filling in for Representative O'Havison today.
Thank you, Mr. Chairman.
We have, one bill hearing. We'll go ahead and get started with that. House Bill 2451. And I believe Natalie is not going to cover this for us. Is that correct,
Mr.
Natalie?
Chairman. Oh, yeah, sorry. Yeah, I brought in the big guns for this one. David Weiss from our office is going to brief this for you, but don't get used to this level of service. He's only with us for today.
Okay. Well, David, if you could let us know what this bill's about, I'd appreciate it.
Thank you, Mr. Chairman. Good afternoon, members of the committee. Representative Miller gets to hear me all the time in insurance and pensions, so I'm sure he's thrilled today. But House Bill 2451 amends KSA 50-6A03 and directs that beginning with calendar year 2022, so January 1st, 2022, certain payments from tobacco products manufacturers not participating in the master settlement agreement would be remitted by the Director of Taxation to the State Treasurer and credited to the Kansas Endowment for Youth Fund instead of deposited into a qualified escrow fund as is required under current law. The amount of such remittance to the Director is set at 0.0188482 per unit sold. That's the current amount under current law. And then the Department of Revenue and the Attorney General shall promulgate rules and regulations as necessary to implement the new remittance requirements. The bill does require that the Attorney General have to certify that the manufacturer did not seek a credit or refund within 1 year of the remittance to the Director before the Treasurer would actually make those deposits into the Kansas Endowment for Youth Fund. The bill also adds language allowing a tobacco manufacturer that remits money in accordance with the above paragraph to contest the amount of the remittance and can seek a credit or refund to the extent that the manufacturer establishes that the amount required to be remitted was greater than the master settlement agreement payments that the manufacturer would have been required to make if the manufacturer had been a participating manufacturer. The manufacturer may elect to receive that excess amount as either a refund or they can have that as a credit against their future remittances. The bill also amends KSA 50-6A01 to include a policy statement to require that tobacco product manufacturers that have not entered into the master settlement agreement to pay directly to the state an amount that there's four specific policies there. Why this is directed, I won't read through that. I think you can see that in the bill. There is kind of a unique provision within this bill. You might have, as you're looking through the bill, you might say, what are these new sections 5 through 8? Section 9 of the bill kind of addresses this by saying that in the event that all or any portion of the amendments to KSA 50-6A03 made by the bill are judged by a court to be unconstitutional or invalid, the Attorney General is required to then make a certification to the Secretary of State that that adjudication has occurred. And upon receipt of such certification, the Secretary of State would publish a notice in the Kansas Register. Then on January 1st, 2022, and the date of publication in the Register, sections 1 through 4 of the bill would be repealed, and the new sections 5 through 8 would actually become effective. And what sections 5 through 8 really are is just actually would be a return to current law. It would be as if, the amendments in sections 1 through 4 under 2451 did not take effect. They would be repealed. We'd bring back sections 5 through 8, and then kind of basically just resume the status quo and have those funds be directed towards the escrow instead of not, and it would not be directly deposited in the Treasury. So the bill does take effect upon publication of statute code July 1, 2021. So the sections 1 through 4 would be the law as of July 1, 2021, except in as section 9 provides if there was that adjudication of unconstitutionality and validity then we would have this, which I think has been called the snapback provisions, to then repeal 1 through 4, reinsert, become 5 through 8, become effective, and then that becomes the law going forward in that situation. So I know it's sort of a youth thing. It's a little bit different, kind of a fun thing to draft, but I can stand for any questions at the appropriate time, Mr. Chairman.
Thank you, David. Questions for David? Representative Carmichael?
Thank you, Mr. Chair. Mr. Weiss, welcome to the committee. It's nice to see you here. We appreciate you bringing your wisdom and expertise to us. I want to talk to you, though, about this repealer and revivor provision upon a finding of unconstitutionality, et cetera. I can't think of anywhere else where we have a statute that works that way. Are you aware of other places that we've done that in our statutes?
Mr. Chairman, Representative Carmichael, yeah, I am not aware of this. This is a sort of a unique provision within law. I mean,
I think what happens typically, say, let's take the criminal sodomy law. It was repealed by, somebody from Texas, it now escapes me, but, the Supreme Court ruled that law unconstitutional years ago as it related to consenting adults of the same sex, but it remains on our statute book. The court, by its order, doesn't repeal the statute. It just says it's unconstitutional. And are there other states that you are aware of that use this mechanism to automatically, upon the entry of a court order, certify that there's been a court order and then revive an old statute?
well, this is not technically a reviver. I mean, there are instances where we have revived statutes in the past, but that does actually then require, a later bill by the legislature to do that.
I'm sorry, snapback. I couldn't remember the word snapback, and I've never heard of it in the law before. Are there other states that utilize this procedure? If you know, and I'm not going to hold you to it.
I don't know. Each state has a little bit different, constitutional provisions on how they enact, amend, revive laws. So I'm not aware of any. I don't, but I think each state could be a little different.
And does this automatic trigger or snapback, does it activate upon any finding of unconstitutionality, no matter how minor or what part of this enactment is affected? I mean, I can't think of an example, but maybe, something extremely minor, just anything at all. And is that judgment left solely up to the Attorney General to decide whether or not a court decision, in fact, does hold this legislation unconstitutional?
Yes, Section 9 there, if you look on page 20 of the bill, the last page.
Right.
If it's all or any portion of the amendments made, specifically the 56A03, are judged by a court to be unconstitutional valid, then it's up to the Attorney General to actually certify that adjudication in the Attorney General's purview. But yeah, it'd be any or all portions of it. So it could be.
Well, I'm always interested in new ideas in the law, so I'll wait for the Attorney General's office to explain it. Thank you very much.
Other questions for David? Seeing any, we will move on to proponents. And it looks like the Attorney General had enough of us earlier this week, so he didn't come see us, but his chief deputy did. So Jeff, welcome to the committee. We gave him a hard time the other day. We'll be nicer to you.
Well, thank you very much. Good afternoon, Chairman Patton and members of the committee. Thank you for the opportunity to testify in support of the passage of House Bill 2451. I'm going to give you a little bit of a wind-up before I make the pitch for the office here. Whenever we're talking about tobacco, and in particular about the Master Settlement Agreement, this agreement now is 23 years old, and a lot of times it's probably good just to give a real brief overview of what the agreement is, what it does, and why we're asking for what it is that we're doing today. So I'll just take a couple of minutes to ask that, and that'll help put in context what it is that we're requesting. So back in the mid-1990s, various states got together and filed suit against the major tobacco manufacturers under the theory that the products that they were selling was causing damage not directly to the smokers, but to the states themselves who are having to pay for the healthcare costs of their Medicaid recipients and other folks who the state paid for their health care. As a result of that, there was first a settlement involving 4 states, and those 4 states was Texas, Minnesota, Mississippi, and Florida, and they settled with the tobacco companies in 1997. But the remainder of the states, and then you throw in District of Columbia, Puerto Rico, and the 4 U.S. territories, entered into a settlement agreement in 1998. And that settlement is what's called the Master Settlement Agreement. It's the Master Settlement Agreement that provides all the terms under which the state gets its money each April. That results in the payments that we get. And now, by a decision of the legislature, those monies go into the Kansas Endowment for Youth. And that was the policy choice that the legislature made. The grand deal of the money was that the tobacco companies would pay money to the state in perpetuity. The present value of that settlement back in 1998 was $206 billion in the present value back then. And there were also different types of bans on marketing to youth and other advertising bans that were done. But at the same time, the state had to give assurances back to the tobacco companies because not every manufacturer of tobacco was going to enter into this settlement. And so what you were going to have was going to be a tremendous price differential between those companies that settled with the states and those that didn't. And in order to offset that price differential and to also to protect those healthcare gains that the states made in the bargain, it was decided that all of these non-participating manufacturers, and that's what we call them, the NPMs, those are the ones who did not sign on to the MSA, that they would put some of the money for all their sales in the state are put into escrow. And so they count all the sales that they made in a year, they're placed into escrow, and they must remain in escrow for a period of 25 years. At the end of 25 years, that money can roll out and then is returned back to those manufacturers. But while it remains in escrow, that money is subject to claims, that if anybody wants to make a claim against that money for purposes of any injuries that they've suffered, there is already that pool has been paid into, but it also maintains the price differential. So each state is required by the terms of the MSA to have what they call a qualifying statute. And the qualifying statute is what was agreed to in the MSA, that every state has the provisions that have these escrow agreements that are in their statutes, and that we agree to diligently enforce our escrow agreements and all the requirements that the state has to live up to as part of its deal under the MSA. So in the early 2000s, there began a series of questions as to whether the states were doing what was required in order to keep up their part of the bargain. That was to diligently enforce our obligations. And so the states ended up in arbitration, and these arbitrations have been tremendously complicated and lengthy. Back in 2012, we entered into a settlement agreement with the principal participating manufacturers to settle all the claims that Kansas had not been doing everything that we needed to do in order to diligently enforce. So we bought out or at least settled all the claims for all potential liability that Kansas could have had that would have required us to have returned part of the monies that we had already been paid for tobacco under the tobacco payments to us. And in addition, we've also gone forward and all the way up through the present date, we've settled all of those diligent enforcement types of claims. We now believe we have fully in place everything we need to meet all of our obligations under the MSA to say that we've diligently enforced all of our obligations under that agreement. But what we're coming up to now is we're getting close to that 25th year. And that 25th year is when the first round of escrow payments are going to be rolling back out. So we're getting to a situation where those non-participating manufacturers can essentially endow their own escrow payments. So as they roll back out, they can actually use that money to pay the next round of their escrow payments. And we think that the incentive of these NPMs to join the MSA and also our ability to continue to diligently enforce that agreement has been affected or will be affected by that. So we've had discussions amongst all of the states that have been part of the MSA, and we've engaged directly with the tobacco manufacturers who are part of the MSA, all the big players, principally Philip Morris and with R.J. Reynolds, and then numerous other tobacco manufacturers. And as a result of this, we came up with the concept that what if we were to convert those escrow payments into what we call an equity fee? We would not change the amount or the way it's calculated, but instead of having that money go into escrow and roll back out to those non-participating manufacturers, instead that money would belong to the state of Kansas. It would be collected by the director of the Department of Revenue. And then we would take that money, and after we've certified that it has been there for a year and is not subject to refund or credit, then we could take that same amount of money and give it over to the Kansas Endowment for Youth Fund, which would be an amount that presently would be right about $9 million annually. So that's the concept, is to take that escrow money, move it from an escrow account and move it into equity payments. This is all prospective. So everything that's been done in the past, all that escrow money will be returned as the agreement and the statutes have always provided. So everything that's been paid in the past, as it hits the 25th year, will be returned as the law has provided. This will just say that from this point forward, starting after the law goes into effect, which would be for tobacco sales that start in 22, that those funds, as they pay in the payments, those will go to an equity, there will be equity fee payments that will instead inure to the benefit of the state of Kansas directly and not be returned as an escrow payment. So that's how this works, and that's what we're asking to do. So here's 2 points that would like everyone to understand. That we have that part of the MSA is that we had to have a qualifying statute. And the qualifying statute was something that we agreed to with all the participants to the MSA. That was all the other states, as well as all the signatory tobacco companies to the MSA. So we've had to shop this concept to every single participant, and all of them have signed off on this. So if we need it to pass in this form. If it's modified or amended in any way, the deal is off. Because the promise that was made to us by all of the people who have agreed to this was that it has to be passed in this form. So we would ask that it be passed unamended, because if you amend it, then we no longer have the assurances that it would be a qualifying statute. So that is one of the reasons why we've had to ask that this pass in this form. And Representative Carmichael, I know you're going to have the question on the snapback provision, and I don't know if I'll wait for your questions, and maybe that would be the best way to address those, to let you ask them. So that way I can hit all of those. But the principal reason we need to have the snapback provision in that way is that we can never have a time when we don't have a qualifying statute. So we have to constantly be in compliance. So we're in compliance now we have an assurance that we'll be in compliance when the law is amended, if it's amended. But if for some reason it were to become unconstitutional and thrown out, we can never have a gap. So we couldn't have a period of time in which we'd have to come back to the legislature and ask you to re-implement the law. We had to have some provision that would allow it to go back into place immediately with no gap in time. And we went to the revisor's office and said, this is our problem. Can you help us solve this problem? The revisor's office said that this was the way that they felt was the best way to accomplish this task. I don't know, any other way to do it. We've never seen it before. And so I guess in answer to your question, Representative Carmichael, it's new to us too. Nothing that we'd ever seen, but we believe it does work. And so that's how we got to that snapback provision, which you'll find in Section 9 of the bill. So with that, I think I'll stand for any questions that you have and appreciate the opportunity to present this testimony.
Very good, thank you. Representative Carmichael with a question?
Thank you, Mr. Chairman. First, Mr. Cheney, I want to publicly acknowledge that a year or so ago, I gave the Attorney General a bit of a hard time in connection with some other, a different bill that had to do with the Attorney General. I kind of characterize it as taking over all sorts of tort litigation on behalf of municipalities. And I alluded back to the events of 25 years ago or more. And I do want to acknowledge that the work that you did then in connection with the tobacco matters has obviously over the years paid benefits, not only in terms of dollars, but also in marketing restraints and a number of other things. So I want to make sure that I've said that. I did some looking last night to try to see if there are other states that have confronted this problem statutorily and how they resolve the circumstance. And I got the general impression that this may be the maiden voyage statutorily to try to fix a problem which is not going to be unique to Kansas. Can you bring me up to date on what the National District Attorneys Association is doing and what other approaches might have been taken to this circumstance?
Yes, we're first. We agreed to go first. This came and started the concept when General Schmidt was chair of the National Association of Attorneys General. So we agreed to be the test case, so to speak, on this. I know that the two states that are next up in line behind us are Maryland and Illinois. They're the ones who've shown the most interest, and so they will probably be the two that line up right behind us. But there will be a large number, I think, that if we are successful and are successful in defending our statute from what will doubtless be a challenge, that there will be surely quite a few others to follow. But we are first.
And that leads directly to my next question, with the chair's permission. If I were one of the non-participating companies, NPMs or whatever, however you say it, I sure wouldn't like this idea. So I doubt that they've signed off on this idea. Can you give me a general concept as to how it is we can enact a law constitutionally that applies to one set of manufacturers but not another? I mean, equal protection of the law. There's some thoughts that immediately come to my mind. Can you help me work through that, please?
Yes. Although we'll be the first of the MSA states, we're not going to be the first of all the states. Texas has done this. They're not an MSA state. So Texas passed an equity fee bill and has withstood all constitutional challenges. So this has been done in one other context, but it wasn't in the context of the MSA. But in this case, these are still payments that are required. There's no increase in payment. They've been paying the escrow all along, so it's not a matter of an increase. It's just simply a question of the conversion of the funds from an escrow to the equity fee. But there's no real doubt that, that the product causes whatever harm to the state of Kansas is no different than that of all the parties that have settled with the state who are all part of the MSA. So we don't.
And certainly don't,
Yeah.
I certainly don't disagree with any of that, but it seems to me there is a difference here, and that is in the initial escrow payment, the non-participating manufacturers have a possibility of getting their money back, but I don't think with this equity fee, they ever get their money back, do they?
No, their equity fee would not come back at all unless they could demonstrate that the fee was greater than what they would have paid had they been a member or part of the MSA, in which case it could be refundable or utilized as a credit. And of course, they're not required to sell in the state of Kansas. If they chose to not sell, then they wouldn't have any obligation to sell their product. And because it's
Well-
all prospective, it's their choice.
Yeah, being a nicotine addict myself, if there's any business I'd like to run out of Kansas, it's the tobacco companies. So I won't make the political argument that we're open for business. I understand why you need the snapback. As best I can tell, this is a good idea. Thank you, Mr. Chair.
Representative Humphries.
Thank you, Mr. Chairman. I kind of don't know where to start. So I think it's similar questions to what Representative Carmichael had, but if we could just go back and I think you can explain this. When you made the non-participating tobacco manufacturers agreed to the escrow payment, but now, and in 25 years, you're getting it back. So now it's an equity fee instead, and they're not going to get it back. So didn't we agree with them almost 25 years ago to do it a certain way, and how can we change it?
We've never had an agreement with the NPM.
Okay.
We we put in an escrow system, and they chose to pay the escrow as a condition of doing business in the state of Kansas. They could sell product. If they sold product, they had to pay in the escrow. If they didn't want to pay the escrow, that meant they just wouldn't do business in Kansas. So it's all been voluntary all along. And it still will be voluntary. It's just that the money that they pay will convert from an escrow to an equity fee.
Okay, that explains it. One other just quick question. The Kansas, the Endowment for Youth, is that the children's cabinet? I mean, okay, thanks. I was just confused by the terminology because I knew that, I know about that from being on other committees. I think that's it for now. Okay, thank you. Thanks for explaining that.
Other questions, committee? Representative Neely.
I just have a question. Are you anticipating that any of the NPMs will not sell in the state of Kansas because of this?
I would expect that there could be some that may choose not to, probably smaller companies that don't do a lot of business in Kansas may decide that it's not worth the while to do it and may choose not to, but I would imagine that the larger companies that do business will probably still continue to do business.
Do not see any other questions. Thank you. Thank you for coming over, Jeff. Anyone else in person or online as a proponent? I do not show any listed neutral or opponents. Do we have either one of those present or online? Don't see any. So let's close the hearing on Representative Jennings.
We go back to Jeff just for a second.
Sure. He thought he got off, but come on back up, Jeff.
Yeah, right. So I'm curious, do you have any concerns that in the event there was a determination that the provisions that are being inserted in here as a change were found to be unconstitutional, that a court might also find that the snapback piece is not valid, and then therefore there would be nothing left, and the potential that the state would be out of compliance and lose the entirety of the MSA?
we're not concerned about that.
Thank you.
Any additional questions? Okay, now the hearing on 24.
Yes, Mr. Chair, I'm sorry, I
Oh,
couldn't get my hand up.
Representative Carmichael.
Thank you. Ms. Cheney, why aren't you concerned? That sounds like a devastating prospect.
I don't think that anybody would particularly challenge a snapback provision because that would be the goal. I mean, the goal would be to move back to the escrow. I can't imagine that they would, I mean, it would be undermining the goal of the entire challenge. So I would suspect that that wouldn't be what they would ever want to do. But
I haven't thought the issue through, so I'll just leave it at that. Thank you.
Any further questions? Do not see any. Now the hearing on 2451 is closed. So committee, we also have 2412 to begin working, but I think let's stay on this for a minute. So as I shared with you yesterday, my hope was, if you're all comfortable with it, that we would take the contents of 2451 and put them into Senate Bill 273. I don't recall in 3 years ever even asking you to work a bill on the same day we've heard it, let alone sticking it in a Senate shell. So this isn't something I try to do often, but we do know that the deadline is this week, and this is something that appears to be that we need to do this session. As Representative Heiberger pointed out, my threat that we work tomorrow is certainly an option, and I don't want to preclude that as an option. Would hate to make you all be here on Friday afternoon, but that's certainly something we can consider. Or if it doesn't get out today and nobody shows up with me tomorrow, then leadership would have to figure out what happens next week. So there are certainly options, but what's everyone thinking on that? Representative Owens.
At the appropriate time, Mr. Chairman, I would be happy to make said motion.
Any concern? I don't know that we have to, because we're working a bill we've already heard, 273, and we didn't hear it today. We don't have to suspend the rules, but I want everyone to be comfortable.
Mr. Chairman.
Representative Carmichael.
Thank you. First, I've tried to exercise a little bit of diligence to see if I could find anyone who had any proposal to amend 2451. I've not found anyone. And moreover, as Mr. Cheney has explained to us, were we to amend 2451, wait a day so we can have an amendment, we might as well not even pass 2451 because it vitiates the purpose of the legislation. So I think given these extenuating circumstances, it would actually be a wise exercise of judgment to work this bill and do as the chair suggests. Thank you.
Okay, I'm not seeing anyone glaring at me except for Representative Heiberger, but I know he doesn't like these types of things. Just kidding. Okay, committee, so let's work 273, and instead of having Natalie go through everything that was in it, that was the Senate's KEMA bill that we didn't like so much, and we went to conference and came up with Senate Bill 40. So 273 we don't need anymore. So the motion would be to remove the contents and put in 2451, if that's what you'd like to make, Representative Owens.
That is correct. Although after the previous representative's talk, I'm not sure I'm any longer comfortable making that. No, I'm just kidding. That was just a joke. I do make said motion that we take the contents of 2451 and place them, we remove the contents in 273 and replace them with the contents of House Bill 2451.
Seconded by Representative.
Oh, darn, I wanted to get in there in view of Representative Owens' comments. I apologize.
Seconded by Representative Jennings. Discussion. I guess this is actually an amendment, so let's vote on the amendment first, which is to swap out the contents. Any discussion? Seeing none, Representative Owens, you may close.
Thank you, Mr. Chairman. I close.
Heard the motion. All in favor say aye. All opposed say no. Now we are on 273 as amended. Representative Falsetto Howison. Well, hold on one second. Representative Miller.
I'd just like the record to reflect that I was glaring at you.
Thanks. Representative Miller.
The ranking member indicated he'd talk to everybody whether or not they had an amendment. He didn't talk to me. I have an amendment. Again, just kidding.
I'm sorry, I emailed my new colleague on the committee. It did not speak to him. I apologize.
Okay, so now is there a motion concerning 273 as amended? Representative Hoheisel,
Thank you, Mr. Chair. I move that we pass out a SB 73 favorably as amended.
there's second. Representative Neely, any discussion? Representative Miller.
You want that as a substitute bill?
We probably do want that as a substitute bill. Is that what you'd like, David and Natalie? David's nodding. So yes, as a substitute bill.
As a substitute bill.
Good with that, Neely? Yes, okay. Any discussion? Seeing none, Representative Hoheisel, you may close.
Thank you, Mr. Chair. I close.
Heard the motion, all in favor say aye. All opposed say no. Motion carries. Those wanting their affirmative votes recorded, Owens, Hoheisel, Heiberger, Neely, I'm assuming Carmichael, let's see here, and Carmichael. Anyone else? Okay, now let's move on to 2412. And Natalie, would you like to refresh our memory again today in case we forgot from yesterday?
Yes, Mr. Chairman, thank you. House Bill 2412 enacts the Kansas Fights Addiction Act to establish a grant program for the purposes of preventing, reducing, treating, and mitigating the effects of substance abuse and addiction. It also attempts to consolidate some of that litigation into the Attorney General's office by providing a process for municipalities to give up their claims and have the Attorney General litigate those on their behalf.
Any questions for Natalie? Okay, amendments. So yesterday you had sent out an amendment from me, and then you had two amendments sent to you by Representative Carmichael. The amendments they don't go well together, so let's start with mine. Well,
Could I
preference?
suggest instead? Actually, Mr. Chairman, I've discussed these matters with you in a limited fashion, and I don't want to be tedious, but even more so, I don't want to engage in futile acts. I don't think that either of my balloon type amendments will probably get on in the committee. And so I don't intend to offer them today. I will save my breath for the floor. And I had a third suggestion that we add the opioid 911 Good Samaritan bill because I think the subject matter fits and I could make a good argument for that. But on the other hand, then I would be guilty perhaps of combining good legislation with bad into one bundle. And I think philosophically that's wrong. So I do not plan to offer amendments here today, Mr. Chair.
Okay, thank you, sir. And I assure you we will keep working on that 911 bill. And I'll be ready to argue with you on the floor on the other amendment. So,
Save
so
the breath,
then you have
yes.
my amendment. I have forwarded it to Representative Miller. Did you get it? I think it was the first one I sent. I don't know if it has my name on it or not. Okay, perfect. So this is the amendment that came as a result of a couple of the parties. Again, not all of them working together, but the Attorney General, some cities, the league was present. Kansas Association of Counties has confirmed that they support this language. We actually had a representative of a county in on those meetings. The attempt was also to address the concern rate, not really a concern, the suggestion raised by the Kansas Association of Addiction Professionals in their neutral testimony. You've all had 24 hours now to look it over any, well, let me move the motion. So I'll make the motion to amend, second by Representative Hoheisel. Any questions about what this does?
Mr. Chair.
Yes, Representative Carmichael.
Thank you. In view of the fact that we've still got a long time till 5 o'clock, could I ask that the reviser or you just give us a real quick shot of the high points to make sure that we have a good recollection of what we're about to do?
Sure. Natalie, you want to take a stab at it, and then I'll add commentary if need be.
Sure. Thank you, Mr. Chairman. I'll put it up on the screen here so you guys can see it as well as we walk through it. So The big change appears here on page 2. Subsection C creates a new fund, which would be the Municipalities Fight Addiction Fund. That fund would be administered by the Attorney General, but the purpose would be to disperse funds to the municipalities. And so when the state received money from litigation, opioid litigation, the state treasurer would put 75% of that deposit into the Kansas Fights Addiction Fund, which is the fund that was already in the bill, and then 25% it would be deposited into this Municipalities Fight Addiction Fund. The purpose of those monies would be very similar for programs to prevent substance abuse and mitigate substance abuse in the community. Although these funds would also be able to be used for attorney fees and kind of repaying municipalities back for expenses that they have incurred as a result of opioid litigation in their communities. And you'll see here kind of at the end of this balloon that municipalities, the money would be distributed to municipalities that have not filed opioid litigation and municipalities that have filed opioid litigation but have entered into an agreement with the Attorney General prior to January 1 of 2021 that releases their legal claims arising from that covered conduct to the Attorney General, and any future claims would be released to the Attorney General as well. That is the big change. The other change here, and I should say that that agreement would be made between the Attorney General, the League of Kansas Municipalities, and the Kansas Association of Counties as to how to disperse that money, and how much each municipality would receive from those funds. The change here on page 3 is the change related to the Kansas Association of Addiction Professionals. So now one of the Attorney General appointments up here on page 1 at line 37, the Attorney General would consult with the Kansas Association of Addiction Professionals in making one of his appointments. We also had a paragraph 3 here, providing that the Attorney General would be able to take any action necessary to ensure the greatest possible recovery from opioid litigation and to seek funds for both the Kansas Fights Addiction Fund and the Municipalities Fight Addiction Fund. And then the primary changes here in section 6 are really just cleanup, talking about municipalities filing or becoming a party to opioid litigation, a pretty technical change there. And those are the changes.
Thank you, Natalie. Representative Carmichael.
Thank you. A question for the carrier of the amendment. I'm a little bit concerned about the broad language regarding the Attorney General is authorized to take any action, and that seems pretty broad. Can you explain what we're trying to accomplish here and how we make sure that we are not granting to the executive branch unlimited powers to do things that the legislature never contemplated?
This language in the discussion with the parties is we wanted to make sure that by entering the agreement or waiving their ability to sue or assigning their rights, we just wanted to make sure that the Attorney General still had the ability to pursue the greatest amount of recovery for the state, so we could use that as a state to fight, to fight back against these opioid addictions and those types of things. And so that's why this language was added in there, just to make sure that the Attorney General knew that they needed to take whatever steps necessary to seek those funds. And so this was the language that was agreed upon. Certainly would entertain better language if you had some to suggest, but this is what the parties agreed to.
Yeah, well, I'll just confess to you that I understand the intent may be good, but as we all know, the court looks to the black letter of the law, not the good intent of the parties who drafted it or the parties who are going to execute it. And I have concerns about this, but I will also say that overall, I believe that the amendment is a good one. It improves a very bad bill. It makes it only a bad bill. And so the risk associated with that broad grant of authority, I think, is outweighed by the good provisions of the amendment. So I appreciate you hearing me out. Thank you.
Any further discussion on the amendment? Not, I will close and move my motion. All in favor say aye. All opposed say no. Okay, further amendments. Not see any. It's a pleasure of the committee on 2412 as amended. Representative Hoheisel.
Thank you, Mr. Chair. I move we pass out HB 2412 favorably as amended.
There's a second. Representative Humphreys. Further discussion. Representative Heiberger.
I have a question. Were the League of Kansas Municipalities involved in negotiations on this, and are they satisfied?
Yes. Is that correct, Amanda? You're not, but you're here. Representative Carmichael's hand disappeared. Any further discussion? Not seeing any. Representative Hoheisel, you may close.
Thank you, Mr. Chair. I close.
Heard the motion. All in favor say aye. All opposed say no.
No.
Motion carries. Affirmative votes. Owens, Hoheisel, Neely, Heiberger. Negative votes. Representative Carmichael would like to be recorded. Well, committee, I think we've done our work. I appreciate everyone's time and the energy you've given to our committee throughout the course of the session. We've passed out a lot of bills. I started working on it this morning to count, and I got distracted, and I'll get that report out sometime. But we have done a lot of stuff, and I should thank Representative Ralph, because every time we pass one, you know what that means. He has to write a bill brief, and he spends many evenings, and I'm sure this evening we'll be working on bill briefs because he got quite the list. Yeah, Representative Ralph.
Thank you. Thank you, Mr. Chairman. Along those lines, I did just receive an email, and I want to give you a list of the numbers that they're asking bill briefs for. The thing that I want you to, please, if you would, if there's something that you would like to carry, or several, if you could email me as I pass those out, because with 13 bill briefs to do, everybody's probably getting something. So it looks like they're asking for bill briefs on 2389, 2366, 56, 106, 5014, 4, 60, 122, 172, 204, 283. So if any of those are ones that you have an interest in, asking for something might get you to a spot where you don't get something you don't want. And if you don't care, that's fine too, folks, but just if something caught your interest. Thank you, Mr. Chair.
I think he just gave away his secret. When you all get the email that says Chairman Patton asked you to carry, that's really from Representative Ralph. Representative Hoheisel.
Thank you, Mr. Chair. Vice Chairman Ralph, if you could email that list to me, just because I didn't get jotting them down until about halfway, so.
Can do that.
Thank you.
In addition to Representative Ralph, obviously Kathy, thank Kathy for all her work and the entertainment she's given us. Thanks, Kathy. She's had 2 knee replacement surgeries since we've last seen her. I guess she wants me to disclose that, but I just did to the world. She's doing good. We hope to see her when we get back after break, that she'll be here with us a little bit. And then, of course, our revisers, research, and IT staff have done a great job. We've worked our way through this and appreciate them. So again, thanks, everybody. We've got our work cut out for us next week. Lots of bills, hopefully, coming from our committee. And then we've amended them all, so we'll have fun in conference after that. And hopefully we see a lot of our stuff cross the line. So appreciate it all. Have a great evening. We'll see you all soon. Thank you.
Mr. Chairman, Representative Samsel, will you send that email to the whole group, please, that Representative Hoheisel asked for, or at least include me, please?
We'll do it, Representative Samsel. Thank you.
Thank you.